Welcome to Leadership Mastery. This is a program that was designed by CPLS for lawyers, judges, mediators, and arbitrators. The purpose of this forum is for leaders in our profession to share their history, their knowledge, and their wisdom, their gems, if you will. Past guests of the Leadership Mastery program included Leon Hanley, who's 94 years old, and he was 94 years old when he participated in this program, Charles Tiffany, and retired Judge Robert Evans. Today we have the pleasure of talking to Judge Leonard Fleet, J. Leonard Fleet, that is. Judge Fleet graduated with his Bachelor's of Arts degree in Business Administration from the University of Florida in 1956. In 1959, he obtained his J.D. Juris Doctorate from University of Florida School of Law. In 1994, he obtained his Master's in Judicial Studies from the University of Nevada at Reno. It included in his accolades of academic achievement is a stint at Pepperdine University, where he studied advanced mediation techniques and training. He has practiced law for over 20 years, focusing primarily in criminal defense and civil rights law, and he spent over 20 years on the bench serving as a circuit court judge in Florida, presiding over civil cases, criminal cases, family cases as well. Judge Fleet, welcome.
Thank you. It's a pleasure to be here.
Now, I've just told the audience a little bit about your background. Can you expand upon that, maybe starting with the formative years for me?
Well, I'm a native Floridian, born and raised in a small town in North Florida, where my grandfather settled in 1903. The Fleet family remained there for close to 100 years before the last of the Fleets retired and left the county. During that period of time, I was witness to segregation and what I now know is homophobia. I didn't realize it at the time, but that's what it is today, and that's what it was then. As a result of the experiences of that, I began to question the social order in which I was being raised. My family were very wide open as to people, person, places, religion, political beliefs didn't matter to them. It was a matter of integrity with the persons with whom they dealt, and that became very important to me. I had an experience when I was 9 years old in which a statement that I thought was anti-Semitic was made to me and reduced me to tears. An African-American gentleman, whom to this day I know only as Mr. Ulysses, sought to comfort me for what I was going through, and I told him what had happened. He started explaining to me how to handle it a different way, and ultimately at the end of our conversation, he pulled back the sleeve of his work clothes and says, "You know, under my skin, I'm the same color as you." Those words were my first lesson in civil rights and have lived with me from that time, the age of 9, to now I'm 85, soon looking at 86, and nothing has changed. By the time I was in the 10th grade, I knew I was going to be an attorney. The question was, what kind of an attorney? My family preferred that I would go into medicine, but that didn't satisfy me. I witnessed a particularly bad set of circumstances involving an African-American lady and a white doctor. Witnessed in the sense I was in the town when this event happened. I saw the local reaction to it. I understood then the only contribution that I could make to a reduction of this horrible racial prejudice issue in which I was being raised and was then living would be within the field of law. In my analysis, physicians could take care of your body, members of the clergy could take care of your soul, and it was up to lawyers to cut through all of that and deal with people as a whole. To me, undergraduate school was a necessary evil. I was ready to go to law school by the time I graduated high school. But smartly, my parents insisted that I go to undergraduate school first, and I went to University of Florida. Accidentally took a couple of courses that later turned out to be extremely helpful as a criminal defense attorney. I took a biology lab course and had to engage in the autopsy of my own rat, dissect it, understand what was there. The mistake I made is I was competing with persons who were going into veterinary medicine, holistic medicine, all kinds of persons, pre-dent, and I didn't have the kind of grades in chemistry to compete with that. Indeed, it took me 4 semesters to finish a 2-semester chemistry course. But
reinforcement is important.
But that too turned out to be a very positive thing when I started practicing law. Once I got out of law school, and I must confess, I was not a good student. I simply did not know how to study. But ultimately I got out. It took me 2 tries to pass the bar exam. And shortly after I passed the bar, I went into practice for myself as a solo practitioner.
So how old were you when you began your solo practice?
Well, I got out of law school when I was 27, I think. Let's see, 4, 7. I was 25 when I got out of law school. I was married, and 1 child was on the way. And the proximity of the impending birth of that first child may have interfered with my concentration on the bar exam. I got home from taking the bar exam at 6 o'clock in the evening, and at 11 o'clock the next 2 o'clock the next morning, I was taking my wife to the hospital to deliver the baby, which was born a few hours later. That the desire to practice, the desire to get my hands into, and my intellectual capacities into this business of fighting the mores of the South, to fighting for those persons who were today considered the little people.
And so when you started up in your practice, during the first phase of your practice in your professional life cycle as a lawyer, you focused on 2 areas of practice. Am I correct?
Well, when you open your office, you take anything that'll walk in. I took in some collection cases at the request of an attorney from Miami and started working for 5 cents on the dollar. But I had 10 or 12 people with whom I was coming into contact, many of whom developed into future clients, which led to other clients, and the practice started growing. Within 6 months to a year, the practice was paying for itself. I associated with another attorney for a while, with a couple of other attorneys. Learned from them what their techniques were and their interests were, and finally joined up with a fellow by the name of Robert Fewer, who unfortunately is now long gone. And Bob and I shook hands on a deal, and for 9 years we were partners.
Now, during this 3 and 4 years, during this initial stages of your professional life cycle, looking back at it now, what critical knowledge do you think you needed at that time that you wish you had?
Frankly, I didn't know anything about business. Lawyers aren't taught business in law school.
But your undergraduate degree is in business administration.
Didn't learn a thing. I majored in public finance and taxation. They taught me nothing about business. Taught me about economics, international economics and national economics, but didn't teach me anything about running my own business. I had, growing up, the marvelous experience of working in my parents' store, which was a retail dry goods store, selling men's, women, and children clothing. And now I had to learn how to deal with people from all strata of life, from those who were obstinate, those who were cooperative, those who were wealthy, and those who were poor, and still learn how to maintain equilibrium, personal equilibrium, with all of them. My father didn't know it. He did not finish high school. He didn't know it, but he was a great teacher when it came to learning how to sell. Indeed, when I was in law school, I got a job selling motor vehicles as part of my means of defraying my costs of law school. Sure. Of course, my favorite job in undergraduate school was when I was a waiter in a sorority house. That was very exciting. Never had a problem with dating. Never spilled anything on anyone. But it gave me an appreciation of the service community. Those things all fed into what I decided to do with my life as a lawyer. And in those years, those few years when I was still practicing alone, it didn't matter what kind of case I took, because I didn't have to worry about offending someone else's client. I didn't have to worry about conflict of interest of taking a client that someone else in the law firm could or could not have represented. Once Bob Fuhr and I joined together, he did primarily civil litigation, personal injury litigation, and I was doing all the criminal offense work. Ironically, he had mostly Jewish clients, and I had mostly Catholic clients. And Bob was Catholic.
So in addition to the skills and the knowledge that you talked about that you needed, that you learned growing up in your family store, the human relations skills, the skills about providing value to your customers, are there any other skills that you picked up in law school that you didn't pick up in law school that you find would have been helpful in those first few years of your practice?
I was very lucky to have two particular teachers in law school, both of whom made their courses very interesting and both of whom demanded research. Learning how to move amongst the various books at the time, this is long before any computerized research was available, but learning how to go from Corpus Juris Secundum to the Florida Report to the Southern Reporter and move through those books looking for cases of import to whatever project I may have then be working on was a technique that unfortunately many attorneys don't study today. It's simply not taught in law school. I found that doing my personal research, doing that rudimentary research, I would pick up information in some area which I was not handling but seemed interesting, and I'd make a note of the citation. In later years, when I came across a case involving that problem, I already had it in my notebook, and I had a starting place. Those notebooks that I developed over the 23 years as a practitioner became extremely important when I got on the bench. Whatever problem was presented to me when I was on the bench, I could look into my collection of 3-ring binders, which by that time was probably a dozen different binders on everything from evidence to unclean hands to contracts to damages, you name it, pretty much was covered in those 12 volumes of stuff. That's all I can call it, is stuff that I had collected. I even had a whole book on just the humor in law to learn how to write an appellate brief that would not be dry. I learned very early that appellate court judges and trial court judges will read every page of a 15-page brief or memorandum, and they'll read about 15 pages of a 50-page brief or a memorandum. I learned the technique of getting to the point quickly, making the presentation different from what is normally said. Once I was on the bench, I became very annoyed to have lawyers submit a memorandum on law, for example, on the Fourth Amendment search and seizure, and they would quote the Fourth Amendment as the opening line. Well, if I didn't learn that in law school, I would be very handicapped. So there was no need wasting time telling me how the Fourth Amendment was developed.
Right.
I wanted to know, how does it apply to this peculiar set of circumstances we're dealing with? As a private attorney, I didn't have the funds or the desire to hire investigators. Whatever investigations to be done, I did it. I never tried a case without going to the scene of the event, be it a personal injury case or a criminal case. Indeed, and reading everything that showed up in the newspapers or any publication was extremely important when it came to my case. The very first time I tried my very first-degree murder case, about 1963, there was no pretrial discovery available.
4 years out of law school, you're
Right.
trying a first-degree murder case.
4 years after, yes. And there was no question about being certified or anything then. It was a very high-profile case. When I was a child and would go to the barber shop to wait my turn to get a haircut, there was a table of magazines in the back of the barbershop that children were not allowed to read. I now know them and later found them to be National Detective, American Detective, or United States Detective. There were stories of high-profile cases, usually very gory and very lascivious in nature. Two of those magazines wrote about this murder case that I had been retained to represent. Since the state wasn't going to give me anything, I detailed one of my secretaries to read both of those magazines and keep a tally of how often a particular detective's name appeared in either or both of the magazines. And the one who had the highest number of tallies, I figured that was the source of the information. And that was the person upon whom I concentrated. We did one other technique. Because we had no pretrial discovery, when my clients were incarcerated, I would urge them not to make bond so that I could file a petition for habeas corpus claiming they were being illegally restrained, which then required the state to present a very strong case to the court to justify continued detention of my client.
So during the phase of criminal practice in the state of Florida, when the state wasn't obligated to provide discovery to the defense and there were no depositions allowed, you came up with strategies.
You had to. You had to be able to figure out what is it the state doesn't want you to know. And once you had that, as I learned from another very good lawyer, a phrase I'm about to use, you go for the jugular. You line up all the evidence and presume that the court is going to rule against you on every single motion you make. So where is the weakest point in the state's case? And that's the point of your attack to the state's case. From this same lawyer and I tried a half a dozen cases together, and every one of them resulted in a not guilty verdict, whether it was my work or his work or the joint work. But I learned from him, you say nothing, you make no gesture, you make no movement that is not planned and that is not in favor of your client's interest. Indeed, I was once a witness for the state and was cross-examined by the exact same attorney. That too was an experience. But
now that you brought up this co-counsel and you brought up your partner that you've had for 9 years, during these critical first years of your practice, what were some of the critical relationships that you've had?
I had to make myself known to the judiciary. Broward County at that time had the court system throughout the state of Florida at that time, and only the circuit court tried death penalty cases. That's the only crime that they entertained. The court of record, as it was then called, handled everything from the driving violations to and including second-degree murder. There were more court of record judges than circuit court judges, but I made it a point of going to each one of those judges and introducing myself to them, telling them about my interests, and soliciting the opportunity to be appointed to serve as defense counsel. And this is in a period of time where the maximum amount of money the state would pay would be $500 for fees and costs.
It hasn't changed much.
They give you a little bit more, and I had some deals with that later on when I was on the bench. It was extremely important that the judges knew of me if they didn't know me personally, and they needed to know that whatever I said or wrote could be relied upon, even if it hurt my client, even if it meant I had to confess error as I once did in a case. In court of record, I had 2 clients with the same first and last name charged with the same crime before one judge. And I prepared case number 1 for one defendant, and when I get into court, it's case number 2 being called. And I told the judge the mistake, and it was my fault, and he granted me the continuance, which made it easier for me later on. Another thing that became very important was knowing what we now call the judicial assistants of the judges, then called secretaries. Their status was changed in one legislative session in order to justify an increase in salaries. But the secretaries ran the division. It wasn't the judge setting the hearing. If the secretary found you to be an offensive type of person, you were most unlikely to get a rapid hearing date in the absence of a clear emergency. Favoritism? Perhaps so. Yet, if they knew that you were polite, if they knew that you were reliable in what you said, and that you would not unnecessarily take the time of the judge, much less waste it, they were much more cooperative in scheduling.
Now, so those are strategic relationships that you've had for work purposes. Did you have any strategic relationships that dealt with your practice in the office? A mentor, for example?
Unfortunately, it wasn't until I'd been in practice for a number of years that, indeed, it was the year when I was 34, I was sworn into the United States Supreme Court. I was one of 50 lawyers, who had been selected by the American Bar Association to attend a seminar just outside of Washington, dealing with the concept of social sciences and the law. I had done some studies of that, of course, because I wanted to argue social issues when it came time for sentencing any of my clients. During the 1 week's course, I met a man by the name of Julius Goldstein, who was a lawyer who had practiced for 55 years in New York City. He had started practicing so long ago that he didn't even go to law school. He just read the law, as was the custom then, worked in a lawyer's office and read designated materials, took the bar exam, passed with flying colors, and began practice for himself. He did not do criminal law because, he said, he won a few cases and then he was approached by organized crime and he didn't want to be involved with that. For 2.5 years, well, Julius called me when we got home. He was living in North Miami Beach. And he had said to me while we were at the seminar, we had become very close, he wanted to know the name of a charity with whom he could work because he didn't like not doing anything. He needed to be involved in the law. And I said, I know a great charity. It's called the J. Leonard Fleet Attorney at Law. And we laughed about it. We were home for about a week or 10 days, and I get a phone call from him one weekend. And sure enough, he was still interested, and I invited him up to the house. He and his first wife had died of cancer, and he and his second wife came and had lunch with me and my former wife. We had a lovely afternoon, and from then on, Julius came to the office, and all he would take was $50 a week and lunch at McDonald's. And the reason for the lunch at McDonald's, he liked their French fries.
They do have good fries.
And for 2.5 years, I had this wonderful man who would challenge me, who would raise issues into which I would say, but Julius, that's not the law. He says, well, it should be, and he would develop, help me with the memorandums of law and the appellate briefs that would argue a new interpretation on an established point. We had some degree of success, but what it taught me more than anything else was, don't take no for an answer. Just because the law says what it says, and it has been for 150 years, it doesn't mean it can't be changed. And a perfect example was what was formerly known as the crime against nature. Very simple language with no elements. Whoever commits the abominable and detestable crime against nature shall be convicted, shall be upon conviction, guilty of a felony and incarcerated for 20 years. That was the statute under which all homosexuals were prosecuted. I had a significant number of clients who were in the gay community. I did not believe in the statute. I thought it was unconstitutional. I was lucky that every one of the homosexual persons whom I represented I managed to get a not guilty verdict. Indeed, there was one case where during the voir dire, the white men, women were not then allowed to be jurors unless they volunteered for jury duty. The white men were saying, "Oh, I have nothing against homosexuals." I said, "Well, I want you to meet John Jones, who is an admitted homosexual." And I took him to the jury box, and he shook hands with every person sitting there. The judge couldn't say anything. The prosecutor didn't think fast enough to object. And it's very difficult for a person to find another person guilty after having shook his hand. And I got a not guilty verdict out of that. I learned that there had to be some way to get into the mind of potential jurors. And I came across an article dealing with what does one's sleeping position tell you about that person's true feelings and thinking. And I designed a collection of 8 photographs of 8 different sleeping positions, which represent what you last remember being your position when you fall asleep, and what is the first position you're in when you first wake up, whether it's during the night or later the next morning. I presented that in a particular case. The prosecutor objected. The grounds said, the judge says, on what grounds? And the prosecutor says, I don't know, but it doesn't seem right. So the judge let me do it with the condition that I would give him the key after the trial was over. And I said, I'll give you the key if you promise not to share it with anyone. And that was the deal. I got a not guilty verdict in the case. And it has always been a source of pride to me to have found this in an obscure text. So lawyers, when they're preparing, and judges too, I guess, but mostly the trial attorneys, particularly in the criminal division, must read beyond the law in order to understand how to reach inside that jury box and convince the jury that you're one of them, not that you're someone pontificating who's loquacious and uses a lot of words and tries to obscure something. A simple thing like, how do you convey the concept beyond a reasonable doubt? Certainly, trial attorneys, then and now, are in competition with the television programs. I came up with an idea that I thought was effective, and I got some good results with it. I took a piece of white bread and showed it to the jury. Look at it, it's beautiful, but it has all these air holes in it. And those holes represent reasonable doubt. But if you squeeze it and get rid of all that air, you have this lump, and I'd hold it in my hand, very untasteful looking. That's beyond a reasonable doubt. It's solid. You can't see through it. It's the case. But when the prosecutor talks to you, and then prosecutors usually did, when they talk to you about a jigsaw puzzle, when you put all the pieces together, you can see the whole picture, but then there's one or two pieces missing. It doesn't detract from what the whole picture is. And my argument was those one or two pieces may be the missing points, which you must resolve in my client's favor, because you don't know what those two missing points might have been, and would they be of sufficient strength to cause you to have a reasonable doubt. I used to go to the courthouse and watch lawyers, skilled lawyers. Take time away from the practice, just sit in the audience and watch the skilled lawyers to learn their techniques. Some of what I said came from them. And I didn't hesitate if there was a break in the trial to go up to the attorney and say, is there anything I can do to help? Or what was your idea about such and so? I found that trial attorneys are very anxious, very happy to share their thoughts if approached in a manner in which makes them feel as though they're teaching somebody something instead of trying to compete.
That is a very useful bit of information. I think a lot of times lawyers feel uncomfortable about approaching other lawyers and asking for help, not thinking that if you offer to help as well, they'd be willing to help you. So jumping from the critical relationships, let's talk about emotions for a minute. While you were practicing in private practice throughout your professional life cycle stages, can you describe for us what kind of emotions you were experiencing? Were there times in your practice where you were afraid, where you were scared, where you were anxious, where you were just happy? What kind of emotions were you experiencing if you were to look at your practice of law experience for those 20-something years?
It's similar to the experience with a dedicated athlete might find. I played football in high school. Indeed, that was the only sport at which I had any decent skills. I was essentially a runt, 155 pounds, soaking wet in my football uniform in the days of leather helmets and high-top shoes. Although the program listed me as 155 pounds, they didn't say that I was with the uniform in the water. And I was playing on the line. When the time for the kickoff came, I'm standing there looking at these men that looked like monsters to me. And it was not unusual for me to dribble into my pants. I couldn't control my kidneys until the first clash, when the first contact was made with the first opposing player. I settled down. Indeed, my mother used to ask me, why are you always on the bottom of things? I said, it's because it's nice and safe down there. Same thing happened in the courtroom. When I'm waiting for the trial to start, when I'm waiting for the opportunity to start the voir dire, the questioning of the jurors, I would have trouble to a certain extent of controlling my bladder, and sometimes it would be embarrassing, but I accept that. But when the first question was asked of the first juror, the battle was on, the intellectual battle was on. There was this sense of almost euphoria that settled. Once I was inside the rail, and we were involved in the litigation, I was totally unaware of what was going on outside the rail. My whole world was in the four corners created by the rail, the jury box, the judge, and opposing counsel. And that was true whether it was criminal law or civil law. I could not turn it off easily at the end of the day.
How did you turn it off before you went home to your family?
When I went home at the end of the day, I had to reconnect. In the first 16 years of my marriage to my first wife, that was extremely difficult. She had had a difficult childhood. The open display of emotions was not something she dealt with easily. And here I would come in as wound up and tight as a drum, upset about something or overexcited about something else. I would not resort to drugs, nor would I resort to alcoholic beverages. Never liked to drink alone, and I still don't like to drink alone. And if I could just be alone for 20 to 30 minutes, which is hard to do when you've got 3 children clamoring to see you and climb all over you. But ultimately in the evening, things would smooth out, and then I'd be able to either just sit on the porch or read a book or listen to classical music, and the tension would flow. The real difficulty I had was that I never put my mind to rest. I would go to sleep, wake up in the middle of the night, and start thinking about some case, some legal theory. And I didn't think to take a notepad to bed on the side table and make a note of it and then go back to sleep. And I would just sit there and ponder this thing. Sometimes I'd just leave at 4 o'clock in the morning and go to my office and start working. That takes a toll. And when I was, the divorce went through, and then my first wife and I have remained very amicable. Our children, the children from the first marriage and children from the second marriage, there were certain problems. It wasn't a Brady Bunch situation, but the women worked together.
That really transitions really nicely into my next question, is the challenges that you experienced in your professional life as a lawyer included those challenges with the conflict between your practice and your family.
That's correct.
And what's the lesson there for new lawyers?
Never let the business come before the family, and I was guilty of that. I would spend an 18-hour day working on a legal issue. And like the cobbler's children who had no shoes, my children in the first marriage had no daddy until the end of the day. Because there was always another case. There was always another book to read. There was always another motion to create, another tactic to perfect. So I just couldn't invest myself properly. And it caused some disagreement between me and the children. Children are very forgiving. And today I'm extremely close to all five of we had 6 children, but 5 girls and 1 boy. And I'm very close to all 5 of my girls. When I went on the bench, it became much easier for me to go to work early in the morning. I would leave home about 6, go to an exercise facility where I worked out for an hour or so, shower, dress, and then go into the courtroom and start my morning motion calendar, what you call here in Orlando as the short calendar. We call it motion calendar there in Fort Lauderdale. I was relaxed enough that when I had these short hearings, I could joke around with the attorneys and still be serious. I was able to interact with them on a very one-on-one personal basis. They quickly learned my idiosyncrasies. They wouldn't hesitate to make a joke dealing with them. Indeed, there was a public defender assigned to my division whom I found out was imitating me when I was out of the courtroom. He later became a judge himself, but I happened to look through the back window of the courtroom one day, and there's this fellow sitting in my chair on the bench imitating me. And I entered the courtroom through a back door, and he couldn't see me. And I just stood there for a couple of 3 minutes while he's imitating me.
And his friends let him go.
And his friends let him do it. And then he finally looked around at me and he said, he suspected something wrong, said, "He's behind me, isn't he?" But it's okay, because he did it with a good heart.
So the challenges that you had as a lawyer, how were they different for you when you were a judge?
The robe that judges wear doesn't weigh much, a few ounces, a pound maybe. But unfortunately, some of my judicial colleagues thought it weighed a lot more than that. I was always more impressed with the institution of the judiciary than the person wearing the robe. That awe for the bench was with me when I was a teenager. And a local judge who was very popular in my hometown, whenever I shook his hand, I could hardly think of anything to say. I was talking to a judge who represented the Constitution. Constitutional studies started with me in the 9th grade. I was very fortunate to have a good teacher who introduced me to it. Of course, she introduced me to the Southern version of interpreting the federal Constitution, which is significantly different from the legal interpretation of the Constitution. I have since then studied that. I learned when I was in practice, and I carried this over to being on the bench. In every single case, there is a federal constitutional issue. You must learn to identify it, raise it, and preserve it at the trial court level in order to be able to deal with it in the event of an adverse decision. Similarly, as a judge, when I would write my orders in major cases, I'm not talking about just a simple motion to dismiss, but I had such unusual cases as a fight between the Seminole Indians and the Tampa Tribune, which would cause me to study the Trail of Tears and what was the relationship of the Seminole Indians to the United States, with whom we're technically still at war. I had to study the issues of eminent domain when I presided over the famous case of the bacterium or the pathogen that infected trees. It's called the citrus canker case. It causes fruit to drop early, but it doesn't destroy its usefulness. It's still edible. And I was dealing with the $8 billion a year industry of citrus in the state of Florida.
You were the
alone.
judge presiding over the case.
Yes.
And that created a challenge for you.
Many challenges dealing with the Fourth Amendment and the searches that were authorized by the state with or without a warrant. A whole parade of stuff. And I took a lot of heat on that case. My client was the Constitution. The other person's client was the citrus industry. And we did not see eye to eye. Indeed, one of the high-ranking members of the citrus industry and the former governor of the state of Florida referred to me as the terrorist of the citrus industry. So much. That's just a label, and you live with it. You can't answer it.
So one of the challenges that I'm hearing you say as a judge is that you're often attacked, and you're seen as sometimes an opponent versus a neutral.
That's correct.
Yeah.
I was told early on in my judicial career by a judge who had been a prosecutor, and we had been opposite each other in 6 different major cases, and every single one of them wound up in a hung jury or a mistrial for one reason or another. One of them involved this case which I told you about, in which there was a penny hammered out in which the Lord's Prayer, the 23rd Psalm, had been engraved, and that was the only thing the client had to give me to pay me for representing them, and this particular judge was the prosecutor in that case. That too was a hung jury. But that judge came to me and said, "You're asking too many questions in the courtroom, and the prosecutors are saying you're the other defense attorney." And my response was, "Well, I see people making a mistake. Am I supposed to just sit there and let the mistake happen?" He says, "Well, those people selected their lawyers. If they didn't make a good selection, that's their fault." And I could never follow that advice. If I saw prosecutor or defense making a clear mistake that was going to run contrary to fundamental concepts of justice, I made it known to them. I expressed my opinion. There was one case in which a serial rapist was on trial in my division. Ultimately he was electrocuted for raping and killing a child in Lake City, Florida, in North Florida, and for raping and killing another child down in South Florida, and now he's on trial for raping a 12-year-old in Hollywood. The defense attorney asked for a ruling before the jury was selected as to whether the state was going to introduce a particular piece of evidence. The prosecutor says, "No." I said, this is all on the record. I said, "You realize if you don't introduce that yourself, so you can maintain control of it, the defense attorney is going to introduce it and he's going to ram it down your throat." He says, "Well, I'm not going to introduce it." All female jury, all women of mature years, grandmothers, mothers, they listen to the testimony. Sure enough, the defense attorney puts on this evidence. The defendant even got up off the stand during his testimony and invoked his Fifth Amendment and refused to testify further. And the jury came back with a not guilty verdict. They all came to me after the courtroom was cleared and said the reason they found not guilty is they couldn't understand why the state didn't use that one piece of evidence. That was a reasonable doubt. In my participation in saying to the prosecutor, "Here's what I've learned as a result of my experience, that if there's bad evidence, you introduce it and control it." And when I got on the bench, if I was confronted with a case in which there's a mixed bag about the evidence, I want to talk to the lawyers ahead of time and be sure what's going to happen in the courtroom, so I am prepared with my ruling when the critical time comes.
What type of relationships as a judge were very important to you? while you were on the bench?
I did not engage in courthouse politics. The judges before whom I had litigated showed me were very helpful in helping me adjust to the fact that I can't just say anything and everything that comes to mind. I learned from them I have to accept the fact I've given up my First Amendment rights of free speech once I put on the robe, because everything that you say is going to be reported either publicly or on the court reporter's notes, and it's going to come back and bite you someday. There was one occasion that I was very annoyed with what the county commission was paying public defenders. They were paying such miserly amounts of money, while at the same time they were spending $600, $700 an hour retaining lawyers to represent county commissioners just in case there was anything brought against the county commissioner for a particular act. I wrote a lengthy opinion attacking the county commission and attacking the policy associated with paying public defenders such a small amount of money, but when it came to eminent domain, paying those lawyers huge amounts of money. The source of the money was the same place, the Treasury of the state of Florida. Not only did the county commission not agree with me, but neither did the 4th District Court of Appeals. Because I set the eminent domain lawyers at $50 an hour, which is what public defenders and special public defenders were being paid. One eminent domain lawyer, who was a longtime friend of mine, called another criminal defense attorney and says, "Come take my files at $50 an hour. I'm not going to work. You can have everything I got." Well, I was reversed and higher fees were paid. But the county commissioner in question said, "Fleet's not paying with a full deck of cards. He's never had to set a county commission budget." One of my judicial colleagues called me and said he had a gift, and the gift was a deck of cards, so that I have a full deck to play with, regardless of what the county commissioner said. I simply, and not too long after I got on the bench, a matter of months, I had borrowed money from a local attorney in Hollywood to meet a financial obligation imposed upon me in the post-judgment divorce proceedings. And it was during a period of time when interest rates were running 17, 18, and 20% even for secured loans. I met this attorney whom I knew, and through a private client, he said, he would grant me this loan, would take a second mortgage on your office building, all strictly up and up. A court deputy is on the turnpike in New Jersey and hears that Judge Fleet has been indicted for money laundering. It turned out that the lawyer represented an ongoing criminal enterprise. And that's where the money came from. And that was one of their laundering techniques, was washing this money through me. And I didn't know that. Well, I had to live with that, and one of the senior judges came to me and said, "Don't answer anything. Just keep your mouth shut." That kind of camaraderie is what helped me get through the formative years as a judge.
Who else besides your peers did you lean on, did you rely upon, not only for practical advice and advice relative to the cases that you were working on, either on the bench or as a lawyer, but to deal with the personal things?
Well, there was one time when I found myself under extreme stress, and I went to a psychologist and spent about 6 months, once a week, just meeting with this individual who happened to have the same name as I have, Leonard. And I discussed with him what was bothering with me, and he helped me work my way through it. When I was just 3 days before my 52nd birthday, and I had been on the bench for a few years, fortunately, in the presence of paramedics, I suffered cardiac arrest. I was obviously resuscitated, treated in the hospital. Now, you talk about putting things into perspective. My wife gets me settled in the hospital. Then she goes home and pays the life insurance premium.
Smart lady.
I'll tease her about it all these many years, but that was her quick wit, and we've made a big joke out of it. My wife, Ellen, can bring me down from being inflated with myself very quickly. She doesn't cut me down. She said that her job for the almost 48 years that we've been married is to keep me humble, which is a 24/7 operation. She has a very quick wit, has a very sharp mind, and she knows when I need to be left alone in order to calm down. It was at her urging, plus, of all people, Senator Strom Thurmond, who persuaded me to go on the bench. Strom Thurmond was a guest of mine to speak to the Broward County Criminal Offense Attorneys, an organization which I founded and started in 1968, and today it still exists. And as I'm driving them to the airport, Leonard, what do you think about becoming a judge? Senator, I'm so much of an advocate, I don't think I could do that. He said, you ought to think about it. And I think with those words, I threw away the possibility of a federal judgeship. Be that as it may, a few years later, my wife says she saw the stress that I was enduring in the practice and how it was a 24/7 job. He said, you really ought to consider being a judge. Another judge died, a judge whom I greatly respected and was very close to personally. He had been into his doctor's office for his physical examination and dropped dead in the parking lot after he finished the exam. But that judge, John King, had come out of Cook County, Illinois. He survived that area. He educated me a great deal. He made a big difference. And I realized that as a judge, you can make a big difference in the social order as well as in the legal jurisprudence. You know, I declared for judge in 1981, 1982. There was a vacancy on the bench. I was one of several persons nominated for the bench, and the governor selected someone else. Another judge for whom I had a great deal of respect, Judge Bill Johnson, came up to me and said, you are going to apply again, aren't you? And with that encouragement and the encouragement of my wife, I then filed in July of 1982 for one of 4 judgeships that was available, circuit court judge in this case. There were 16 lawyers who signed on to run for the other 3 positions, and none of them filed against me. So in July of 82, I became judge-elect.
So you've had your 20-something years of practice, 20-something years of being on the bench.
Obviously enough, it was, ironically, it was 23 and 23. 23 as a defense attorney and 23 on the bench.
So 46 years of combined experience as a lawyer and a judge. If you were to look back and look at lawyers right now and in 2 minutes or so, give them some advice, what would that advice be?
Study. Study not just the law. You've got to know religion, whether it's your own or others. You have got to know anatomy if you're going to engage in either personal injury or criminal offense work. Attend an autopsy or 2 and learn the complexities of the human body. Watch senior lawyers, skilled lawyers. Go to the seminars for the purpose of learning, not for the purpose of getting away for a tax-paid vacation.
Or just for the CLEs.
Yes, not just for the CLEs.
Right.
And absolutely do not burn bridges behind you. I represented a lot of policemen during my years as a criminal offense attorney, and I cross-examined many policemen during that same period of time. but I never had a problem being able to sit down and talk to almost any law enforcement officer on a person-to-person basis, man to woman, a man to man, and gain information that would be valuable in terms of my work, either as a trial attorney or as a judge. And don't be afraid to learn from someone younger than you are. Training in sales, not in sales of jewelry, sales in tough products like a motor vehicle. Selling a used car is very difficult because the general public approaches a used car salesman as someone who's not going to be honest. And it's a barrier you have to be able to break down. Work in the legal aid society, because there you're going to meet people with extremely difficult problems who have no money to hire the skills of the elite lawyers to solve those problems. You must be able to be, in Yiddish there's a great word, Menschlichkeit, being a human being with compassion and understanding. And you've got to do that whether you like the opposition or like the people that you represent or not. I never ask a jury to like one of my clients. I just ask them to give them a fair trial. Take the time to listen to what the state is going to say and ascertain whether it is sufficient to convict. There's only 3 questions to be answered in any civil or criminal trial. The first one is the evidence sought to be used constitutionally obtained? Is it, secondly, legally admissible? And third, is it sufficient to carry the burden of proof? If any one of those questions is answered no, the person on trial, civil or criminal, is entitled to a finding of relief, whether it be not guilty of the crime or act charged, or a less serious charge. So you can charge someone with murder 1, and the evidence is only sufficient for murder 2 or murder 3. That's what you look for.
So in this last minute of time that we have here, can you share with us some of your thoughts on what it takes to be a leader in our profession?
Humbleness and determination that you're going to contribute something of value to the society that made it possible for you to be a success. Money is not the measure by which one is a success. When that client gave me a penny and said, "This is all I have to pay you," I framed the penny. And I've kept it all these years because that's the best fee I ever earned. And I've told that story many times to young lawyers who have come to work for me. Yeah, you've got to make a lot of money. You want to make a lot of money. You've got to make enough to cover yourself. But there are going to be cases where the only thing you get of value is the knowledge that you contributed to someone else's welfare. Only when you believe that can you lead others to do the same thing.
Judge Fleet, thank you very much.
Thank you.
I really appreciate you taking the time. Really enjoyed listening to your stories, and hopefully everyone who views the video that comes out of this session will be enlightened as well as we are today. Thank you.
My pleasure.